Hey, everybody, and welcome to Thursday night. Hey, everybody, John Skiba here from the Consumer Warrior YouTube channel. Like we are each and every Thursday night here doing a live Q&A on our live stream, just going over everything debt related, all the tough, awful things out there like bankruptcy, debt collection lawsuits, and all of that. So as far as my background, I am an attorney in the state of Arizona. I do pretty much mostly bankruptcy and defending debt people who are getting sued by debt collectors. And so that's what I'd like to talk about is, if you're dealing with bankruptcy, you're dealing with debt issues, debt collection lawsuits, how we do this, put a question in the comment section or the chat section over on YouTube. I'll go ahead and put it up on the screen and we'll go over it. My disclaimer, it's like I do each and every week, is I'm only licensed in the state of Arizona. I can only represent people who live in the state of Arizona or have Arizona cases. And so if you need specific legal advice and you're not in the state of Arizona, I recommend you contact an attorney there and find out exactly what's going on. This is just some guy on YouTube talking, so take that for what it's worth. You should not take it as legal advice. That's for sure what you should not do. If you're in the state of Arizona, I'm happy to meet with you. I don't charge for consultations. Again, that's Arizona only, though, because that's the limit of what I can do. Man, we have a bunch of questions already, so let's jump right into it. Matthew put a question and supported the channel. Thank you, Matthew. Appreciate that. Matthew says, a junk debt buyer requested a bench trial. The Texas Justice Court rules say I have to request a jury within 20 days of filing the answer. Better to do a bench trial or a motion for arbitration of dismissal. Clerk told me that debt cases aren't considered small claims. I think it goes on to say the city agreement has small claims exclusion, but the justice of the peace court clerk said small claims case type is within the justice court is different than a debt claim case in the justice court. True. So let's unpack that a little bit. So there are typically rules. If you're going to request a jury trial, you've got to do it during a certain period of time, or you waive the right to do it. Jury trials, from the court's perspective, are a huge thing. It's, because it's not just a judge listening to it, but now they've got to bring in what's called a jury panel. They've got to bring all these people in. There's what we call voir dire, where you're picking a jury. And then once you get the jury in place, like the whole role of the judge in the court is completely different in a jury trial than it is a bench trial. And so it's a big deal, and they need to know about it, and they need to be able to get prepared for it, particularly smaller courts where they don't do a lot of jury trials. They're going to want to know well in advance. Let me answer what kind of a question. It's separate from that. Jury or bench trial. Most of my cases are bench trials. I can tell you requesting a jury trial sometimes will have the effect of having the other side say, we're not doing this. It's kind of similar to the request for arbitration. It's really outside their wheelhouse. You're throwing a wrench into their machine, and it's not worth their time and effort. Not only that, I think juries, depending on the state you're in, juries you're going to do better in front of. Sometimes judges become somewhat cynical or hardened, I guess, at all the cases they see. They see thousands and thousands of debt collection cases come through. And sometimes having a jury is just like it's having, it's a jury of your peers. It's having people who understand maybe debt and falling behind on bills, but then they also understand and kind of see, hey, this, especially with debt buyers, this seems a little shady that these guys can charge, pay pennies on the dollar for this and then come after you for the full balance. So, as to your question, is it better to do a bench trial or a motion for arbitration for dismiss? I would do a motion to compel private arbitration. I think that it's likely to be dismissed rather than even having to litigate the thing on the merits. Whereas a bench trial, I always say at the end, the judge, if you're going to the bench trial, it's up to the judge. They are the jury. They're the ones who make the final decision. And so you get a lot of different backgrounds and approaches to it, and there's more risk there. So, and worst case scenario, for whatever reason, they don't allow you to compel private arbitration, you're just going to end back up in trial anyway. So I don't see there's any harm to do it. Now, you bring up a good point, though, with your second question, as it relates to the small claims court. Now, small claim court, like Arizona where I practice, there is a small claims court. I believe the jurisdictional limit is like $3,500. So if the lawsuit is under $3,500, it can be brought in justice court. However, in Arizona, the justice court cases, there are no attorneys allowed. period, for the plaintiff, defendant, anything like that. So if there's an attorney involved, which in junk debt buyer cases, there are always going to be an attorney involved. They're going to bring it in a justice court case. And if you look at the, excuse me, the terms and conditions of a credit card, a lot of times the arbitration clause will have a little line item that says that this arbitration clause does not apply to small claims matters. So what the clerk told you there is true, I think, in a lot of jurisdictions. I know it's true in Arizona that even if it's a collection case, the fact that they have an attorney likely means it's not in small claims. And so that small claims exclusion would not apply. I get started every week and realize I'd better take a drink before I do all this talking. So, Matthew, I hope that that's helpful. I think it is true. I think you're fine there as far as filing a motion to compel private arbitration, even though there's a small claims exclusion. I don't think you're in small claims court. It doesn't sound like so. I think you're fine there. All right, let's see if there's some other questions here. The motion to compel arbitration, we get a lot of questions on that. If you're new to the channel and you're wondering what that is and you're dealing with that collection lawsuit, in the YouTube section at the top, I pinned a link to some of the tutorials I do on how to compel private arbitration to deal with these cases. Nicole says, I filed a motion to compel arbitration, LVNV accepted. LVNV is a junk debt buyer. The judge is asking me to file an arbitration application. What does this mean? Okay, so you filed your motion to compel, and I've always said I think that it's on the creditor to file the case in private arbitration. So there's these companies, there's two of them, AAA, the American Arbitration Association, and JAMS, JAMS, which is an acronym, and I always blank on what it's for. You can just Google those, American Arbitration Association or JAMS, and you're going to see they go to these websites. These are private companies that you're hiring to act as the arbitrator in your case. And so, like, I just filed one recently in JAMS for a case that I'm doing. I feel like the JAMS is a little easier, their interface to be able to do this. You can go on there and you need to actually initiate a consumer claim between you and the other side. Now, so you're going to fill out the information, fill out the parties, fill out who the other side is. It's going to ask you what kind of case it is. It's a consumer case, consumer debt case. And then it's going to ask you, you're going to pay a filing fee. The filing fee with JAMS, I think it's like $200 or something like that. I can tell you in the cases that I've done it, often the debt buyer will just dismiss. If you actually go to the trouble of filing it, it'll go to they'll seek dismissal on it. And so if the judge is ordering you to do that, I would do that. Even though you're going to be out $200, you're going to be money ahead, because my guess is the debt buyer will probably dismiss because they don't want anything to do with that. So that's what you need to do. You need to go to JAMS. You need to go to AAA. All of the arbitration clauses refer to JAMS or AAA, and see exactly what their process is. I'll do a tutorial on that. I think I'll do a little video to show how that gets done. And then you can take a look at that. I'll try to get that up next week so that you guys can take a look at that. But that's going to be the process for setting it up and initiating the case. And then something else that I do, I then file a notice with the court, a little notice that says, hey, arbitration was initiated. I've done what you told me to do. And then often that's when the court will then back off and say, go to it. Go do your arbitration and leave us alone. That kind of thing. So, all right. Let's see what Michael has to say. Looking to file Chapter 7 bankruptcy, but I have a credit card and a checking account with my bank. Do I have to worry about them closing my account due to the credit card being added to my Chapter 7? Great case, or a great question, because this comes up all the time. People ask me about this. They're worried about if they file bankruptcy and they have a credit card with Chase and they have their checking with Chase, is their bank account going to be closed? The answer is usually no. And I'll tell you what the exceptions are. But the bank like Chase, their credit card wing and their banking wing are two actually separate companies. They're just all under the same umbrella. So you would be able to, you're still going to be able to keep your checking account. They're not going to close it. The bankruptcy courts all got together nationally and actually sanctioned Wells Fargo probably about 7 or 8 years ago for this exact thing. Because what they were doing is they were freezing accounts as soon as you filed for bankruptcy, if you had a credit card with them, and the court slapped them around and said, stop it. And if you do it again, we're going to sanction you. And so they've stopped it. And I haven't seen that be an issue ever since then. The place where it can become an issue is if you bank at a credit union. Credit unions have different rules, and most credit unions, if you look at the fine print when you open an account, they will often have something called a cross-collateralization agreement. What the cross-collateralization agreement is it says, look, you have all these accounts, you have your car loan here, you have your checking, you have a credit card, and underneath, they're all connected. We're going to secure all of these loans and these bank accounts. So the effect is if you have a car payment with them and you're not making your car payment, they can just go and swipe money out of your checking account without asking. They don't usually do that, but they can do that. Same with the credit cards and all that. So it is a little bit different. I usually tell people if we're filing Chapter 7 and they have a credit union and they have a checking account there and a credit card, probably to close out that bank account and go bank somewhere else. Because sometimes they'll come in and they'll try to treat the credit card as secured, that is secured by the car loan or secured by the bank account, and it just causes problems. So my opinion on credit unions, when times are good, they are your best friends. They have the best rates, they have the best lending, the best options. When times are bad, they can be your worst enemy because they tend to be more aggressive. They have stuff like the cross-collateralization agreements, and it can be kind of a mess. All right, let's see here. Let's see what Chloe has to say. I applied for and got 2 small limit credit cards before I decided to file for bankruptcy. Should I pay those credit cards off before I file for bankruptcy? The total amount is only $800. If you were one of my clients, I'd probably say don't worry about it. If you have an attorney, 100% go talk to them and see what they say. If you applied, sometimes it depends on whether, if you incur debts right prior to filing bankruptcy. I always look to see, we look to see what the intent was. Did you make some payments, minimum payments or something towards it afterwards? The practical effect is that's not going to cause an issue in your bankruptcy. $800, there's no credit card company on the face of the earth that's going to come into your bankruptcy and object to that, because they probably have to hire an attorney who's going to charge them $350 an hour to do it. So it doesn't make sense for them to do it. Absolutely, if you're looking to file bankruptcy, you should not incur debts. You shouldn't, if you've hired an attorney or if you're getting ready to file, you shouldn't go out and incur debts. But if there's a situation where you applied for them, you got them, you used them, and they're like, you know what, this isn't working, I'm going to file bankruptcy. For that amount, it's not going to cause a problem, at least in my experience. Let's see here. I settled with the creditor to be paid in one lump sum. What do I have to do in order to close the case? Do I need to file a motion for closure, or does the creditor do it? This is a good question. So it kind of depends on what stage you're at in the litigation. So if they file a lawsuit and they serve you, and then you settle it, you reach out to them and say, hey, let's get a deal done. You get a deal done, you pay them, and they say, okay, you're good. If you have not filed an answer, in most jurisdictions, then the creditor can come in and just dismiss the case with prejudice. You don't even have to say anything. They can do it without your permission. However, if you have filed an answer, then they actually have to get your permission, or they're going to have to, there's going to be like a stipulation. Usually what happens is if you have filed an answer and then an agreement is reached, the plaintiff, the creditor, will file what's called a notice of settlement with the court. And they're saying, hey, judge, we've settled this case, and it kind of takes it off of their active case list. And the judges will usually say, okay, you need to file a stipulation to dismiss this case, or it's going to be dismissed on our own if it sits around for too long. So that's what you need to look at, is it whether the case has an answer filed or not. If not, then they'll do it. If an answer has been filed, then they should draft a stipulation that you can sign off on. You want it to be dismissed with prejudice, meaning that it can never be filed again. So that's something to take a look at there. So, Al, thanks again. Thank you for always being here and supporting my channel. I sincerely do appreciate that. Lucy had a question on TCPA violations. Specifically, a debt collector sending unauthorized texts from multiple originating numbers about the same debt. I don't do a lot of the TCPA violations. I've taken classes on them. I think I should. They can be very profitable for everybody, for clients and everybody. I don't handle enough of them that I am super comfortable talking about the nuances of them. But if you go to there's a website, I'm part of this group called NACA, National Association of Consumer Advocates. If you go to consumeradvocates.org, it's plural, so consumeradvocates.org. There's an attorney finder thing there where you can find consumer attorneys in your state. So you can go there and look up a TCPA attorney. That's a specific category that you can find someone to help out with. So, all right, let's see here. Let's go here. I had my case moved to arbitration, but they didn't proceed, and now the court orders a status conference. You know what? I think I was going to answer this. I think I saw this comment in the channel. So I was like, man, I think I've already answered that. So you're asking, can I file a motion to dismiss my case because the lawyers didn't proceed with arbitration? And now the court wants to have a status conference. Court clerk says I can't file to dismiss. The plaintiffs have to do it. I laugh because it's kind of funny. I've had court clerks. I know. In every state, they are taught and they are trained. You cannot give legal advice. And it's just funny because I see here that we've had 2 questions already where the court clerks are giving legal advice. Absolutely, you can move to dismiss. It isn't just the plaintiff that can move to dismiss. And so court clerks are wonderful people, but I would say be very careful about taking legal advice from them because their view of the legal world is different than maybe like what you and your advocates would be. So here's what I would do if I was in this situation. I would go to the status conference. So the status conference is just the judge saying, hey, I want to see what's going on here. Let's see what happened with this request for arbitration. I would prepare a motion to dismiss. I would bring it with me and I would say, Judge, you ordered the parties to participate in arbitration. The creditor didn't file it. And what they will do is they're going to jump up and down and say, Judge, we didn't ask to go to arbitration. And you can say, yeah, but you ordered us to go and I don't have any claims against them. They're suing me. So how am I going to file a lawsuit against myself in the arbitration process? And I would say, you ordered them to do it. They ignored that order. Here's my motion to dismiss. I want this dismissed with prejudice. If the judge balks at that, then what I would recommend is asking the judge to give you 30 more days. Then I would go and I would initiate arbitration myself. Let the court know you did it, and then let's see what the creditor does at that point. That's what I would do. So, all right, let's see this one. Can an attorney report to the court or the U.S. trustee my private asset information that was disclosed in a consultation for filing Chapter 7 bankruptcy if I don't file with him or her? These are the ethical questions. We're getting some hard questions tonight. So when you meet with an attorney in an initial consultation, you're just meeting them just to see if that's what you want to do. Those conversations are usually protected by attorney-client privilege, meaning that the attorney, can't be called as a witness or anything like that to be compelled that against you. So the answer is typically no. The qualifier it says if you don't file with him or her. If somebody comes and meets with me in my office and we do a consultation and they tell me some stuff and then I never hear from them again, no, they're not going to be able to come and the court and say, hey, what did John Doe tell you here? They're not going to be able to do that. It is important to know, though, that when you hire a bankruptcy attorney to file your case, that attorney is ethically bound by the bankruptcy code to disclose all assets. And if you're unwilling to disclose all assets, like I've had clients who have come to me and said, I'm not going to tell them that. And don't you tell them that. I've got to withdraw because now you've put me in a situation where I have to comply with those ethical rules. Despite what you see on TV, TV and movies make attorneys seem like they're kind of just, shooting from the hip, kind of a Better Call Saul thing. Every attorney I know takes the ethical rules serious as a heart attack because it's their licenses on the line and they're not going to jeopardize their ability to continue to practice law and provide for their families, everything like that. So something to be aware, if you're filing bankruptcy, everything's got to be disclosed. I always say this, if everything's on the table before you file, there's usually something you can do to work through it. But the problem is if you don't disclose something and it comes out after the fact, that's where you're going to run into problems. And I can tell you, I have the most terrifying thing as a bankruptcy attorney is when you get like to the meeting of creditors and your client says, hey, they disclose something for the first time. I mean, it's good that they're disclosing it, but it's like, oh man, I wish I would have known that before. So I always say disclose, 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 let your attorney kind of guide you through that process. I also can tell you this, something I've learned, 20 years now I've been doing this. So the bankruptcy trustees, they are contractors for the federal government. They have a lot of access to government records, information. It's not their first rodeo. And so sometimes people will come in and think that they're being, they have a good plan or to be a little tricky here. They have seen everything. There are millions and millions of cases filed. And I always tell people, you don't even want to go anywhere near that danger. It's a felony not to disclose things. I mean, and people do go to jail. I mean, you see, I mentioned before, for whatever reason, it's all these, I'm blanking. The housewives shows is what I'm referring. The housewives of Hollywood or whatever, or of Dallas or whatever. It's a lot of these reality TV shows, I think, where they get a lot of money, they run into some problems, they get into debt, they file bankruptcy, they don't disclose. People go to prison over this. And so, and your attorney can go to prison over it. So that's why I'm always saying to always be very careful. You follow, if it's an overseas asset, it's still got to be disclosed. And so you got to be super careful with that kind of stuff. So, all right. That looks like we got through all the questions. That wasn't too bad. Got through those. I did have, let me look here. You know what? Maybe I didn't get them uploaded in time. I think actually a lot of the questions that you guys, that I was going to ask in the comments, they came and they provided them in the channel tonight. So that worked out pretty good. So, well, great. We can end a little bit early then tonight, but hey, thank you for checking in. If you do want to see some of the tutorials and that, I'd link those up at the top. I'll also put them below this once we post a video here in a few minutes. But I appreciate y'all checking in tonight.